Journal entry of judgment. A lot of these are going to be fairly similar to what we had on the PSI. They're just kind of in different spots. Again, we've got the heading is the same, and again, just hopefully for ease of use, the drug provision is a little farther down in the sentencing journal entry. On page 2, back to that post-release supervision that you're not going to be using, but just as a reminder, the DUI provision that we've talked about too is now put in the journal entry. Okay, page 3 on the journal entry. This is an important part for the court. Statute provides under 2170 that the court can withhold authority of court services and community corrections from imposing the quick dips. So if the court is desirous of doing that, this is the particular place on the sentencing journal entry that the court will affirmatively withhold that authority. Otherwise, court services and community corrections is able to impose those sanctions. Any questions about that? Yes? Yes. Yeah, his question is what is the practical effect of that? Then field staff would not be able to do that. Therefore, you would just do your motion to revoke like you would normally do. And at that time, the court could impose the quick dip. So yes. All right, down at the bottom, again, under your cost is the same again that we talked about, the DUI for the Community Corrections Service Supervision Fund, and then the Human Trafficking Victim Assistance Fund. One of the other things I want to encourage you on here, since the law has changed with the SB 123, as many of you know, if an assessment is actually done, the offender can be charged the $200, and previously it was $300. If they actually do not qualify for 123 and are not going on 123, then that's what we're asking that the court assess the $200, and they wouldn't be, since they're not on, they wouldn't be seeking reimbursement for that $100. We're asking what's the magic number on the 300? There is no magic number. I will tell you that a legislative subcommittee was convened several years ago. Judge, you remember when that was? It was maybe 2009 or 10, something like that. And they were concerned about offenders not paying anything for 123. And, there's certainly a valid point there. If you've got an offender that is paying on it, he or she has some skin in the game on it, and they may be more willing to continue with the program. And so $300 was the magic number because the average assessment costs $200, and so they wanted the offender to pay at least another $100 onto their treatment. That doesn't mean the court can't order more, and we would encourage the court to order more if they have the ability to do so. Keep in mind, of course, though, that this whole entire thing is usually littered with costs as well. So that's a consideration too. But if they are accepted for 123, we're still asking for the 300. They're just two different lines now. If they're not, then the assessment would only be 200. Again, page 4, you've got the reminder on the post-release supervision. The credit section has been changed from jail credit to incarceration credit. This is to reflect the time at DOC for those graduated sanctions. We've also included house arrest in here at a request as well. So anything that you have as far as credit, including their 120 or 180 time, can be placed in there. These are the registration, the ones we talked about before. Change in the name on bisexual relations, the new crime of commercial sexual exploitation of a child. Ag human trafficking has actually been split up in terms of the type of conduct, and that's, again, a factual type of situation as to where they fall. And then the involuntary manslaughter issue of if it's related to DUI, it's not included. So the ag human trafficking, again, we'll talk about the human trafficking a little bit, and I've got just a few minutes here, but the human trafficking was such that Kansas City area, Wichita area, there were many issues in terms of human trafficking, and part of the problem was the entire dynamic that went into prosecuting those offenses and being successful in stopping that type of activity. There were a lot of referrals, but they were struggling as far as being able to get a handle on the issue. And so, because frankly, the ag human trafficking statute's been out there since 2006, and can anybody guess how many we actually have in prison right now? 2. We have 2 people that are actually have been prosecuted successfully under ag human trafficking. So, and we know that there's many more of those folks out there that are doing these things to the kids of our community, as well as a lot of them that are out of state that they're bringing in. So, so those have actually been that was a major initiative by the Attorney General's office. This is just the same thing on page 2 that includes involuntary manslaughter and the bisexual relations again.